The insanity defense is a key part of our criminal justice system, which is founded on the belief that people normally choose whether or not to obey the law. Certain people cannot make that choice. However, either because they are too young or because of severe mental retardation or mental illness. Elise Senoff, professor of law, from an interview in U.S. News and World Report, 1982. What are your thoughts and reactions to this quote? In some cases, can a person's mental state be taken into consideration if they've committed a crime? Should they be taken into consideration? Why or why not? Take a moment now to respond to this quote and this question. We're going to continue looking at various types of defenses that can be used in a courtroom. More specifically, we're going to observe the 4 different rules or tests for the insanity defense. In our criminal justice system, defendants will be acquitted if they can prove that when they committed the crime, they were legally insane. This defense has existed for hundreds of years and has always been controversial. But public debate intensified after President Ronald Reagan was shot in 1981, and his attacker was found not guilty by reason of insanity. His attacker is pictured here. In this case, John Hinckley Jr. purchased a gun and stalked the president for some time. He wrote a letter to a famous actress called Jodie Foster, telling her what he planned to do, in hopes that he would gain her attention and affection. Millions of Americans watched in horror as the videotapes of the shooting played over and over again on national television. Luckily, the president was fine. How could this person be found not guilty? The American people demanded. For criminal law, insanity has a special meaning, even in this context. Legal scholars and lawmakers have disagreed about what constitutes insanity for a defense to a criminal charge. Over the years, 4 different legal tests for determining insanity have been developed, but none has been universally accepted as valid. The first one is the Mcnaughton Rule. Secondly, the Irresistible Impulse Rule, the Durham Rule, and the Model Penal Code Test. Let's take a deeper look into each of these. Starting with the Mcnaughton Rule from 1843. Under this traditional approach, defendants must show that because of their mental illness, either they did not know what they were doing or they did not know what they were doing was wrong. About half of the states and federal courts use the Mcnaughton Rule. Critics of the Mcnaughton Rule point out that it does not protect defendants who cannot control themselves. Thus, defendants can be convicted under the Mcnaughton Rule even if they cannot avoid committing the crime because of mental illness. In 1887, in the case called Parsons versus Alabama, some states will require that the defendant be acquitted if they can prove that the crime was committed because of the insane impulse that controlled their will. This insanity test often supplements the Mcnaughton Rule approach. The Durham Rule was created in 1954 in a case called Durham versus U.S. In order to prove insanity under this rule, defendants must show that the crime was the product of a mental disease or mental defect of some sort. Because of the vagueness of the rule, only one state still follows it today, and that's New Hampshire. Lastly, we have the Model Penal Code Test, also known as the Substantial Capacity Test. A much stricter rule than Durham, this test is used in almost half of the states. This test was used in the McKinley case. Under the Model Penal Code approach, defendants are insane if they can either prove that they lack substantial capacity to appreciate the criminality of their conduct, or they lack substantial capacity to conform their conduct to the requirements of the law. Some jurisdictions omit the second part of this test altogether. Under any of these tests, defendants who are successful with this defense will be found not guilty by reason of insanity. Often this means that the defendants will be committed to a mental hospital. They will not be released in many jurisdictions until they can prove beyond a reasonable doubt that they are sane or that they no longer pose any threat to society. In Hinckley's case, since 1982, he has been confined in a mental hospital in Washington, D.C. He received psychiatric treatment and antipsychotic drugs. He's currently off his medication, and doctors report his mental condition is greatly improved. In 1999, he was allowed to leave the hospital on the grounds of supervised visitations. Since that time, judges have allowed him to visit his mother's house under her supervision, and the periods he has been allowed at her home have increased over time. The insanity defense is rarely used. One study showed that only 1% of all defendants at trial raised this defense. It also revealed that the defense was successful in just 1/4 of these cases. In other words, for every 100 cases, only one person uses the insanity defense. And out of every 400 cases, only one of them is successful. The defendants were found not guilty by reason of insanity in about 25% of all cases taken to trial. The images you see on the right-hand side are state-run psychiatric hospitals in the state of New Jersey. Lastly, we have guilty but mentally ill. At least 20 states have this verdict. The meaning of this varies from state to state, though. In most states, guilty but mentally ill means the defendant was not legally insane, but was mentally ill when committing the crime. It means that the defendant's defense of insanity has fallen short, but the jury recognizes the defendant has mental issues. These jurisdictions have not replaced the insanity defense. In a few states, guilty but mentally ill replaces the verdict of not guilty by reason of insanity. The verdict in these cases means that the defendant was legally insane when committing the crime. The effect of this verdict is the same in most states. The defendant will receive a standard prison sentence that may serve in a mental hospital. If the person recovers from the mental illness, the person will then serve the remainder of the sentence in prison. A few states have entirely eliminated all insanity defenses. It is no longer a valid defense in Idaho, Kansas, Utah, and Montana. In these states, however, the defense can introduce evidence showing that the defendant did not have the state of mind or mens rea required for the crime. Do you remember that term? We learned it in one of our first lessons in this portion of the class. Now that we've reviewed the different proponents and different tests that can be applied to the insanity defense, take a look at page 44 of your textbook. The class activity is called the insanity defense. Look at Mark's situation and apply all 4 of these different tests. Which one fits his case best? Which ones do not? Of course, if you have any questions, feel free to reach out and ask. You know where to find me.